All right. Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. I'm really excited to have you join us here today for understanding the impact of executive orders on HUD, HHS, and DOJ programs. Before I introduce our amazing speaker, I do want to go through some quick housekeeping announcements. The training is being recorded, so if you register, you're going to receive a copy of this recording via email from Zoom within about 24 hours. That email will also include the CLE code. It will include a link to the materials, including the PowerPoint slides. The training was approved by the Florida Bar for one general CLE credit and one state and federal government and admit practice certification credits. So you get a lot of certification credits there. I will announce the CLE code towards the end of the presentation. I will drop it into the chat. It will also go out via email, so I promise you, you will not miss out on that CLE code. Closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility, feel free to reach out. I'll drop my email in the chat as well. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with PILS, I'm going to drop the link for the Public Interest Law section website into the chat as well. And all this information will also be going out via email. So final piece of housekeeping announcements are for questions and answers. You have the chat and you have the Q&A feature, but we're going to ask you to try to hold your questions towards the end. That way the presentation will flow a little bit better. And towards the end of the webinar, we're going to stop recording to kind of open it up for questions and discussion if possible. So with all that said, it's my absolute pleasure to introduce our amazing speaker today, Morgan Cardinal. Morgan is the director of advocacy at Community Legal Services, or CLS, where she creates and implements the strategic advocacy plan for CLS. Prior to her role as director of advocacy, Morgan served as a managing attorney for the Fair Housing Unit at CLS. In this role, Morgan managed the Fair Housing Initiatives Program grants awarded to CLS through the Department of Housing and Urban Development. Prior to joining CLS, Morgan worked in the private sector representing clients in title claims, first-party property claims, and general civil litigation matters. Morgan is a Florida native, having graduated from the University of Central Florida and Stetson University College of Law, where she was a law clerk with Gulf Coast Legal Services in St. Pete, Florida. Morgan is a member of the Orange County Bar Association and is a member in good standing with the Florida Bar, licensed to practice in Florida state courts, as well as licensed to practice in the Middle District of Florida. So without further ado, it is my absolute pleasure to pass it over to Morgan Cardinal. Morgan, the floor is yours.
Thanks so much, Jorge, and thanks everyone for joining us today to talk about what has been going on in 2025, right? It has been a lot of crazy newsworthy headlines, and so I'm hoping to just really, unfortunately, just I only have an hour with you today, so just scratch the surface a little bit about what some of that has looked like and what that means for us as legal aid practitioners. As Jorge graciously pointed out, legal aid is very near and dear to my heart. That's where I started my career over at Gulf Coast. It's where I am now, here in Central Florida with Community Legal Services. And so I want to make sure that we as a community are able to be knowledgeable about some of these changes and be prepared to address some of them with our clients. So get started today. We do have a little bit of an agenda. We're going to talk about the very basics of what has been happening since January 20th, 2025, when we did have an administrative change, and there have been a flurry of executive actions as a result. I did share with Jorge some materials. I see that he's linked it in the chat. I'll be referencing some of those throughout the presentation. So please feel free to follow along. And yeah, hopefully we can have a nice, robust discussion at the end. So again, we're going to talk about executive orders. What are they? What does this mean for us as a legal aid community? And then some of the resulting litigation and changes that have come from these. And while the focus today has been on executive action, I did want to just draw our attention to the One Big Beautiful Bill that was passed, and some of the impacts that we might see in some of the programs we're going to talk about today. And then obviously, I'm not going to come here and bring all of this bad news without some strategies that I think we can all utilize as legal aid practitioners to address some of the changes that we've seen. So, getting started, uh, executive orders, right? I can't personally think of any time in history where we've seen such a flurry of executive action in the way that we have this year in 2025. It was really day of administrative change. President Trump was sworn in and the executive orders just started flowing, right? Jorge and I actually had joked previously about wanting to do this kind of training much earlier in the year, but just not being able to keep up with all of the changes to be able to do such a training. And so I figured holidays are coming up. We've started to see things slow down. So now let's talk about what has happened. So first things first, what is an executive order, right? It is a written and published directive from the President of the United States to the executive branch, right? It is meant to provide guidance to the federal government about how those executive branches are to implement some of the priorities of that current sitting president. There is an ABA article that was released, as you can see, 5 days after the change in administration because we saw such a flurry of executive orders being assigned and issued at the outset of this presidency. That should be also included with your materials and is just a really good primer for anybody who is trying to understand how these executive orders function within the larger scope of our government. What's important to understand is that executive orders are not legislation, right? These are not the law, right? There's no approval from Congress. There's no real way for turn any of this. This is a separate executive action. Only a U.S. president can rescind existing executive orders, right? Their own or some president previous to their time in office. So it's really important to understand that we don't take executive orders to have the weight of a law or a lot of times really even case law, right? Because this is essentially a guidance from the presidency to the executive branch. Hey, I want to focus on this and I want you to focus on this as well. I think you can kind of get that sense from, for example, the executive order related to FEMA that was issued this year. We won't go into a lot of detail on that one, but that's a really good example because if you'll recall, the order really was a directive to FEMA to review their own processes and provide a analysis of same to the president and his staff within a certain time frame, right? So that was a directive to an executive office, in this case FEMA, to be to undertake an action, right? So as opposed to a law, which usually provides a little bit more detail and explanation as to what is or is not allowed. But in talking about this last point on the slide, only a sitting U.S. president may overturn existing executive orders. I did want to just lift up some executive orders that were almost immediately rescinded when President Trump took office. And the reason I want to lift up these orders is because many, if not all of us, have probably encountered some information or directives or guidance that we were relying on or that our grant funders were relying on, or maybe even some state or local officials in order to implement certain processes and procedures. So you'll see, I think the biggest one in related to these sort of anti-DEI efforts that we were seeing from at the federal level, right? We wanted to there was some a Supreme Court action that really determined that affirmative action was no longer appropriate, and therefore related DEI actions are no longer appropriate at the federal level. And so that resulted in the rescission of Executive Order 13985. Some of us who are specifically working with marginalized communities probably saw this executive order quite often, because that was really where federal grant funders or federal pass-through or state pass-through funders were asking about how the applicants were going to identify the groups that they were going to be working with. We also had, I know in my work when I was in the when I was doing fair housing exclusively, Executive Order 13988, which was the federal implementation of the decision in Bostock, which was an employment decision that determined sexual orientation and gender identity were part of a larger class of sex and gender protections available at the federal level. We saw a lot of information and grant opportunities and guidance related to the implementation of this executive order. I'm sure a lot of us are aware of the immigration enforcement activities that are going on. Some of those orders have been or some of the orders that identified immigration, lessening immigration enforcement activities, or at least finding a pathway to citizenship for immigrants. Those have as well. Orders of the Strengthening Medicaid and Affordable Care Act, that executive order has rescinded. And then discrimination protections under Title IX have also been rescinded. So as you can see, these are the executive orders that are no longer in enforcement at the federal level. They have been rescinded through the Executive Order 14148, which was, I think, probably the first, if not one of the first executive orders that this administration released. I just grabbed a snippet of some of the ones that I think are probably most relevant to our legal aid work, but 70 plus were actually delineated in this executive order for rescission. Things all the way back to Clinton administration executive orders were rescinded. So that is going to change a little bit the way that we interact with federal agencies. Again, these are not laws, so protections that exist by way of statute or case law are still available to our clients. This just really changes the priorities at the administrative level. For example, I think you'll see as grant information gets released or directives get released from federal agencies, emphasis on protections for marginalized communities. Okay, so moving on to some of the other topics that we're going to really get into today, I did want to just sort of list out the executive orders that I think are really ripe for our discussion in terms of what does this mean for what does this look like at this point at the federal level. So one of the first controversial executive orders that came out was defending ideology, extremism, restoring biological trust to the federal government. Yes, the titles are usually a mouthful, unfortunately. But what happened here is this executive order really took a ideological approach and has said that the federal government will only recognize two sexes, male and female. There's a little controversy about the text of this executive order because they do link that identification at the time of, I believe it is conception rather than birth. So I think there's some confusion in more scientific endeavors about when sex really is biological sex rather is really determinable, but for the purposes of this executive order and for federal protections and the mandates that they will issue, the executive order identifies male and female only. And it also therefore directs executive branches to identify protections based on sex as to those genders. So, what that means is we have seen changes in the Department of Education, a lot of changes in the Department of Education, but specifically this change in the Department of Education and the Department of Housing and Urban Development, where protections for sex discrimination had broadly been expanded to include sexual orientation and gender identity. Unfortunately, the executive branch will no longer recognize those protections, which largely means investigations from those types of discrimination complaints will, by and large, probably not be processed by the executive branch. Moving right along, Executive Order 14158. This was everybody's favorite, I think, establishing and implementing the President's Department of Government Efficiency, or DOJ, right? So this was the executive order that allowed the Department of Government Efficiency, at that time helmed by Elon Musk, to start looking around, right? This impacted every executive agency, and it allowed for DOJ to review contracts. There had been a website. I don't know if many of us were following it, but there had been a website that was maintained by DOJ and was keeping a tally of how much money they were saving these executive branches. There again more controversy around this department because a lot of those numbers couldn't be independently verified. And so that resulted in a lot of contracts being canceled, a lot of grant contracts being canceled. Anybody who deals with the Department of Housing and Urban Development certainly remembers at the beginning of the year where contracts were terminated and then they weren't terminated, and so causing quite a lot of confusion. I will tell you, as of November of this year, actually right before Thanksgiving, it was reported by OMB and OPM, which is essentially the Office of Management Budget, and then like HR for the federal government, reported that DOJ was no longer in effect in the way that we had seen it initially at the beginning of the year. It's really kind of become a more in-house process for specific agencies. So rather than having one for the entire federal government, there have been mandates to specific agencies to undertake these contract reviews and determine if there's waste, fraud, and abuse at the federal level. So the Elon Musk helmed DOJ, as we remember hearing all about at the beginning of the year, no longer seems to be in effect. That doesn't do us a lot of good here in Florida, because as of today, when we are talking about this, the Florida DOJ is still operational, and it is still going what seems to be county by county to investigate waste, fraud, and abuse, similar to what the federal agency was doing, but now here at the state level. And then Executive Order 14159. This was strengthening and unleashing America's law enforcement to pursue criminals and protect innocent civilians. This is an executive order that rescinds prior executive orders on enforcement, border processing, and family unification, and expedited removal processes, and then further denies federal funding to sanctuary jurisdictions. And so this was really the kickoff to the immigration enforcement that we have started to see kind of percolate throughout most, if not all, of the federal agencies that we may be working with in legal aid. So these kind of areas, and you'll see that there are a number of kind of subparts, particularly when it comes to DOJ. It was created by one executive order, and then it was given implementation and effectiveness through another executive order. But these are really, I think, had the most wide-reaching impacts for some of the federal agencies know and love. I did want to really briefly, because we are talking about the Department of Justice, in this training today, I did want to just give a special kind of, this is not so much a specific topic that we'll cover in depth today, but just a highlight for us all to be aware of is that Doge is really, or I'm sorry, the DOJ is really responsible for the enforcement piece of some of these executive orders. And so what does that mean for us? Again, these are implemented at the federal level. So they're really monitoring and ensuring that the federal agencies are implementing these executive orders in the way that the administration wants to see them implemented. And so that gives DOJ kind of a lot of authority to really look not only at the agency, but then the organizations that are working with those agencies to ensure they're all on the same page with these executive orders. So specifically, there is an executive order listed here, improving oversight in federal grant making, that allows the DOJ to really see and provide oversight on federal grants that are issued to non-federal entities. What that means for us is not a huge change in what our obligations are. We're always going to be responsible to understand the grant terms that are provided and to make sure that we are following all regulations that impact those grant terms. There was something called the False Claims Act that was always sort of in the back of any sort of grant implementation that with money from the federal government, which allows the DOJ to essentially enforce if somebody is making misrepresentations in the application or receipt of federal funding. I had not, in my time, had not necessarily heard of the DOJ really pursuing false act claims against grantees. I think they probably had more important things at that point to really pursue. But that had always been an enforcement remedy available to the DOJ. Now we have this specific executive order in addition to false act claims Act legislation that really gives the DOJ a heightened I won't say a heightened opportunity rather than obligation. We'll say heightened opportunity to really be investigating grantees for their use of what their representations in grant applications and their subsequent use of federal funds. So I highlight this here because it is going to be really specific to the grant that you've applied for and the contract that you are working under if you receive those funds. But I do want to, for our group listening, kind of keep that in the back of your mind now more than ever. I think there will be heightened scrutiny of the application of grant funds, and we need to be aware of that because there are now these two mechanisms, executive and legislative, that have really given DOJ directive and opportunity to pursue enforcement should there be a discrepancy in the application of those funds. I say that knowing full and well that none of us on this call would ever have that problem. But, now is the time to maybe double check your record keeping and just make sure that, every T is crossed and every I is dotted. Okay, so starting with my favorite, HUD. um, the what what the kind of landscape of what we're going to talk about today is, I kind of cherry picked litigation that has been filed in response to some of these executive orders that I highlighted at the beginning. One, because I think it will hopefully provide a calm for the presentation to let everybody know that there are folks that are recognizing the problems with implementation of some of these executive orders, and they are pursuing the necessary mechanisms to try to make sure that these executive orders cannot impact our work and, more importantly, our clients. But all of that takes time. So this is really just an attempt to up on some of this litigation and where it stands today. There are over 400 cases. Last I checked, I think we might be closely crossing the 500 case threshold against this administration. And so that's everything from against the presidency directly to specific federal agencies, brought from organizations all over the country. And essentially, the heart of what these lawsuits are attempting to challenge is the sort of failure, as it were, to appropriate Administrative Procedures Act and make these sort of blanket changes result as it results from the executive orders. And as we mentioned before, executive orders are directive. I'm going to say this a million times, so get ready. Executive orders are directives to executive agencies. What they cannot do, though, is override existing law. And that's sort of what the theme of a lot of these cases are going to be. And so right off the bat, we're going to talk about the National Fair Housing Alliance versus HUD, which was a lawsuit that was brought by the National Fair Housing Alliance as a representative of the organizations that conduct fair housing work. So across the nation, the National Fair Housing Alliance has the ability to make representations and to protect and stand in the shoes of those maybe smaller fair housing agencies that were impacted by this, but maybe don't have the ability to bring these claims independently. And so HUD, essentially citing the DOJ executive order, was it essentially stopped issuing and renewing grants, right? It just froze everything. And so, as I mentioned before, a lot of our smaller fair housing organizations were at risk of not being able to operate. And in some cases, these would be organizations where they're the only organization in their entire state that is looking at housing discrimination cases. So the National Fair Housing Alliance really jumped on trying to support those organizations and filed this lawsuit, which resulted in a temporary restraining order to stop the implementation of this executive order at HUD, which was ultimately moved into, based on the showing of National Fair Housing Alliance, into a preliminary injunction, and which required HUD to release their the grant funding that was appropriated by Congress, date certain in the case. One of the most important things that I think we'll talk about today is this idea that the federal government really works in conjunction with one another, right? No one branch of the federal government can do something solely on their own. And in this case, there is a body of law, the Administrative Procedures Act, that talks about how administrative funding is and administrative procedures should be issued and implemented, at least at that base level, right? And so this court really helped to reaffirm that administrative actions are, or administrative discretion rather is the term that they use, is really based on what the appropriations clause of the Constitution and then also the Administrative Procedure Act hold. So that was a really good outcome. I will say there haven't been a ton of updates on this case because that funding has been released. And so a number of us on this call may have received the updates that, we were approved for certain funding and now we're just waiting. Thanks in large part to the government shutdown, right, to get those contracts inked and in place for 2026. Similarly, so this was for funding that had not been released but was appropriated by Congress. Massachusetts Fair Housing Center versus HUD was focused on actual grant terminations. And so uh, recipients of HUD funding had received termination letters at the beginning of the grant, basically determining that due to implementation of executive order 2025 executive orders, those contracts could no longer be they were written, and so they were being terminated. Again, and here I say it again, maybe there's a prize at the end. I'm not sure. But basically, what was happening is these executive orders were essentially being used as a way to trump existing law, right? And so, as I mentioned, we do still have the Bostock opinion as case law. And while the executive order itself was rescinded, the case law is still good and sound law. And therefore, we could, as organizations, working with low-income clients that may be experiencing discrimination, we could still bring cases under the Bostock opinion, whether or not HUD agreed that that was appropriate administratively. It was still available in the courts, and therefore Massachusetts Fair Housing Center, brought this lawsuit basically saying it was not appropriate to terminate those grants because the work could in fact still be done. This case still remains stayed, and from what I understand, most of those grants were either reinstituted or able to end in the ordinary course. Um, we have the Rhode Island Coalition Against Domestic Violence versus Kennedy. This is sort of a HUD HHS Health and Human Services hybrid case because it really was seeking to put conditions on federal grants, which would have required domestic violence and housing organizations to certify that they don't promote gender ideology, diversity, equity, or inclusion in order to continue to receive their funding. Again, this was another case that was blocked with a preliminary injunction to allow that work to go forward because of a potential violation of the Administrative Procedures Act, as well as the First and Fifth Amendments under the Bill of Rights. So again, this luckily preserved HUD's housing grants, such as continuum of care and emergency solutions grants, as well as HHS's Family Violence Prevention and Services Act funds, right? Because otherwise, unless you were able to certify that you're not providing all of this information, which is really hard to do, when we're talking about specific funding that is generally used, like specifically when we're talking about domestic violence, we all know here that a large percentage of those who are survivors of domestic violence happen to be women, happen to be families. And so we would be specifically providing this services to a specific group of people, which would put us at odds of being able to say that we're not promoting some of these ideals around specific gender ideologies. So then that leads us to HHS, which has had quite a lot of litigation during this administration. I tried to pull out some of the high points just relative to the work that we are all doing, but a lot of the cases that have been filed against this administration really do have to do with some of done at HHS. So the first case, which has been temporarily blocked, is it concerned the 2025 Marketplace Integrity and Affordability Final Rule, issued by HHS and CMS being the Centers for Medicare and Medicaid Services. It was trying to significantly alter the requirements and procedures for qualifying for Medicaid services and for the marketplace health insurance, which was created by the Affordable Care Act. The District of Maryland actually halted 7 key provisions of this law of the final affordability 2025 rule, again saying that administrative and financial barriers, and in this case these were barriers that were put in place to specifically prohibit the exact groups that should be benefiting from the Affordable Care Act, should not be in place, at least not simply by rulemaking in this way. And so the decision again preserves the existing ACA operations administered by HHS and CMS and the Treasury, and prevented the abrupt changes before the 2026 enrollment cycle. So the final rule here would have changed people's existing eligibility and existing coverage before a new enrollment cycle in 2026. So it kept, and what it was able to do, what this lawsuit was able to do, it was able to ensure that advanced premium tax credits were maintained, self-attestation procedures were still allowed, and that open enrollment remained in the same process as prior to this 2025 rule. Also, I just highlight here that California filed a similar lawsuit directly against the Centers for Medicare and Medicaid Services, and it ultimately resulted in fairly similar outcome. Because of the this lawsuit against HHS, the City of Columbus lawsuit specifically, it's going to have very similar results in California. And then the next case, Doctors for America versus Office of Personnel Management, as I mentioned, Office of Personnel Management is essentially like the HR department for the federal government. There were several federal directives related to the executive order we discussed at the height of the presentation, regarding defending women and establishing the male and female gender, that biological male and female gender would only be recognized as the federal government. And so it also resulted in a lot of our federal resources being scrubbed of information related to sexual orientation and gender identity issues. So that we saw that at HHS, CDC, NIH, National Health Institute, CDC being the Center for Disease Control. Sorry, I'm trying to define my acronyms for all of us, so just bear with me. And then the Federal Drug Administration removed a lot of the references to sexual orientation or gender identity issues. It also included removal of information on contraception and maternal health. And so basically, the judge in this case went ahead and vacated the OMP memo and HHS guidance, holding that they were unlawful under the APA. And so while that means that information should have been restored and available, I think practically speaking, we're still sort of fighting for implementation of this court order so that that information is available again. When we get to the discussion section of, be interested for anybody who is regularly checking for that information to see if it has been issued yet. I think the answer is partially, but not totally. So it'll be interesting to see how how much longer that goes on. And then that was similar, another case, very similar body of complaints in that in Massachusetts, where we have Schiff versus the Office of Personnel Management, again, challenging the removal of health related data, which by and large had the same outcome as the Doctors for America case. And so we're hoping that that information will be restored if it hasn't already. And then just really quickly, kind of continuing with the HHS theme here, we do have some some fun kind of data potential data breach issues where 20 states sued HHS for the transmittal of Medicaid beneficiary data to DHS, the Department of Homeland Security for Immigration Enforcement. So recall a few months back where the Department of Homeland Security entered into joint memos with several other executive offices, basically agreeing to information share. HUD had one. I know HHS obviously think there were several others where they all agreed to cooperate and share information on individual statuses. And so this was a lawsuit that is currently still awaiting court ruling and about the cooperation between HHS and DHS regarding the immigration status of Medicare recipients, Medicaid and Medicare recipients. All right, moving into DOJ litigation. This one was hard to nail down because the DOJ is named in a lot of these lawsuits, probably because of the note that I made at the outset regarding who's really going to be enforcing some of these executive order rules and implementations. But first, we'll talk about the state of New York versus the Department of Justice. You know, as a aside for those of us on the call that just find this stuff interesting, you will notice a lot of these cases are being brought by similar organizations and out of similar circuits. Obviously, that is you know, within good reason, right? These are nationwide issues. We sort of have many organizations that are being impacted. And so the state of New York has sort of led the charge. You'll see Massachusetts, the state of New York, DC, Rhode Island being repeat players in a lot of this litigation, sort of taking the helm for organizations that are going to be impacted, which makes remembering these cases super fun because the parties are all the same. But starting with the first state of New York versus Department of Justice is challenging an administration policy to sort of revisit the Personal Responsibility and Work Opportunity Reconciliation Act from 19 right? They're going way, way back, this administration, to look at some programs and try to alter the program's ability, how they function and eligibility. So some of you may refer to this as Priora, or the Work Opportunity Act. It's it a bunch of different names, but it does impact a lot of our clients. This was an attempt by the administration to include immigration status checks for nearly all federal social services, and would have forced citizenship verification before admitting people to shelters, food banks, domestic violence centers, things that are generally considered to be an emergency need, and you would have to go through an immigration check. So this was thankfully temporarily blocked. The Department of Justice is actually appealing that injunction that was put in place. And the court did find that this was an arbitrary uh, implementation of agency policy after ignoring years since 1996, years of settled interpretation. And so where we're at today is right now, HHS, Department of Labor, Department of Education, HUD is not able to limit services, particularly shelters, food banks, and domestic violence shelters, centers, without a person showing their papers. But again, this one is under appeal. And then our second, State of New York versus Department of Justice, which has also been temporarily blocked. And actually, this case has, since I put this presentation together, has actually been dismissed because this was essentially a update to Department of Justice guidance impacting VAWA, VOCA, and Burn JAG funds for legal aid and for legal aid services to undocumented clients. So VAWA being the Victims of a Crime Act, or I'm sorry, VOCA being Victims of a Crime Act, and VAWA being the Violence Against Women Act. And then the Burn JAG funds, these are all funds that help domestic violence or victims of crime that came from the Department of Justice through grantee organizations. They actually implemented in September a condition that services could not be provided to any removable alien or any alien otherwise unlawfully present in the United States, which would have limited protection orders for victims of crimes. It would have really limited sex trafficking work that some of our, as well as obtaining UNT visas or continued presence status while litigation is ongoing. So the state of New York and a coalition of other states sued, basically saying that is in contravention with the laws that implemented these programs, so VOCA and VAWA specifically, basically saying that this guidance, there is no citizenship eligibility requirement in those laws, and therefore there shouldn't be that in the guidance. So the good news, I'm happy to bring you some good news today, is that the parties, so in this case, the state of New York and the coalition of, I'm not 20, not 20, I'm sorry, the other coalition of states were able to work with the Department of Justice to clarify the guidance. That order clarifying the guidance is part of the materials that I shared with you all. But essentially, the DOJ has agreed that interpretation of the guidance will remain in compliance with VOCA and VAWA. And so that way we can continue the services that we provide regardless of citizenship. All right, and then just some fun miscellaneous cases I wanted to bring to everyone's attention. They didn't really fit into some of the other categories, but just be aware that there's a lot of movement at the CFPB, particularly this sort of zero funding request that was issued by the CFPB. They essentially agreed not to follow through and not implementing or not doing their job, right? Not doing what the CFPB is required to do. And so this case was ultimately dismissed. However, we do see a second case, CFPB being the Consumer Financial Protection Bureau. And so we see the next case, which really hits at what ultimately happened, right? So CFPB still only made a budgetary request of $0 and issued this directive to sort of cease all CFPB activity. In the mayor and city council of Baltimore, they said, we're still going to do what we're supposed to be doing, but they still only have $0 to function. And so we see shortly thereafter a Rise Economy versus Vought. Vought is the name of the current chair of the CFPB, who has delayed implementation of, in this case, specifically the Small Business Lending Transparency Act. and or transparency rule rather, which requires reporting on small business loans. That has still not been implemented at this point. There some final rule, but it delays the compliance for and enforcement for fairness concerns is what they're stating. And so we have yet to see a final rule or really any enforcement on this interim rule. So while CFPB has said they will continue to operate, they are maybe not so much, and that could potentially be due to the zero funding request that they made for 2025. And then finally, for a couple of additional cases that are sort of miscellaneous but outside of CFPB, we do have a Social Security Administration case where they are where disability rights organizations are essentially have filed suit against the Social Security Administration and DOJ and their leaders, alleging a lot of the workforce reduction that came as a result of oversight is essentially preventing folks who are entitled to who are entitled to receive Social Security Administration benefits. It's slowing down that process because we're seeing a reduction in force, closing of offices, and things that are otherwise making it very difficult for the folks that we work with to obtain their benefits. There's not a ton of movement on this case, but I will say through the grapevine, we have heard of some conversations that are being had with SSA to resolve some of these issues. So there may be a resolution on the front, but it's certainly going to be a lot of negotiation before we get there, right? Because they have a reduction in staff, and so we're going to have hurdles to overcome with that. And then IRS and Medicaid data sharing. So this was similar to HHS and DHS sharing information. That this relates back to another interagency initiative that allowed immigration authorities to access data linked to individual taxpayer identity numbers. This was unfortunately denied. The block was denied because the court was unable, or the plaintiffs, according to the court, were unable to identify a clear standing or a clear likelihood of success. So this group is in the process of appealing, and so we're kind of yet to see if that immigration data sharing will be blocked, but as of right now, it is not. And then this is just a fun sort of FYI, since I probably am talking to a number of federal grant recipients. I did want to just shout out that there are a number of lawsuits related to indirect cost caps that are being implemented by various federal departments. So most of them at this point have been blocked. So those caps should not be in effect. But because they had been deemed to be likely arbitrary and capricious caps, but just know that at the temporary restraining order or permanent or preliminary injunction is, just that, temporary or preliminary. So these cases are continuing to move forward. And so we don't have a final ruling in some of them. So keep an eye on whether or not there could be a change in your indirect cost gaps, or caps rather. Keep wanting to say gaps. For those of us who don't deal directly with grants, just indirect cost is really sort of the administrative component that goes into the cost associated with administering a grant. And it's usually a number that is approved by the agency that you're working with. You can make requests for changes periodically. Sometimes there have been caps, sometimes there hadn't been, and a lot of agencies are now looking for specific caps, and most of those attempts had been blocked at this point. So some litigation takeaways, just just for the fun of it, executive orders are not law. I've said that 1,000 times. I'll say it 1,000 more times. And so when an agency acts in a way that is inconsistent to the law, which is what Congress has instructed through the Administrative Procedures Act, we are seeing that judges are ready and able and willing to tell the kind of slap the agency's hand and say, no, 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 this is outside. This discretion has gone too far. So under existing case law, in that case being Motor Vehicles Manufacturers Association versus State Farm Mutual Automobile Insurance Company, also a mouthful and part of the materials provided for you today. You've got to see that the agency has, we've got to be able to see when a rule is implemented or guidance is implemented, that an agency has used more than the executive order, right? There's got to be a reasoned, sound explanation for these changes. It's not, they can't just say, well, the executive order said so. So a lot of cases have been um denied or blocked because of this because this reasoned explanation had not been shared. And then finally, one big beautiful bill act. I hate to gloss over this, but I do want to get to some of the strategies in these last few minutes. And I am able to stay a little bit longer for those of you who are also able to stay with me. I will be here, but I did just want to shout out, this is not a budget bill. This was a streamlined process that was passed to allow Congress to make changes to revenue and debt limit and mandatory spending. It is not the bill, the individual bills that fund each agency. So it didn't mandate any spending, which is why we saw SNAP benefits kind of lapse during the shutdown. So some of the things that have come out of this, it does strengthen low income tax credit program, which is great. It permanently extends some opportunity zones, which is also really helpful because those of us who try to get advanced credit on grant applications is we like to highlight opportunity zones we're going to work with, but in the negative, it restricts and cuts Medicaid and SNAP and CHIP. Medicaid being public health insurance program, SNAP being the supplemental nutrition assistance program, which is essentially what we know as our EBT or food benefits for folks, as well as CHIP, which is the Children's Health Insurance Program. So government funded health insurance for children in families that are otherwise make too much for Medicaid. So we have seen a lot of changes already from the One Big Beautiful Bill. I think we're going to see more as folks are able to make their budgeting requests for 2026, which is part of the continuing resolution that we are currently under through to the end of January, where we're going to see actual programs being funded by Congress at probably lower rates than we traditionally do. So quick legal aid strategies, and I'm happy for folks to start putting questions in the chat now as we talk through these things, but I do want to recognize that there is going to be a difference between what LSC funded organizations and non-LSC funded organizations can do. Community Legal Services is LSC funded, so I'm certainly well aware of the restrictions that come with this, but I do want to just highlight there is more that we can do than maybe we're really aware of, particularly if we have a client. So we all should coordinate. I think that's probably common sense, but I'll say it out loud to avoid duplication, right? We should use these forums that we have, the consumer umbrella group, the housing umbrella group, other listservs that exist, to try to figure out what organization makes sense to do what activities, right? Obviously, if it comes into lobbying, LSC organizations are not going to be able to do that, but it doesn't mean that we can't at least share information. So one example I'll talk about is, and this was also in the materials that were shared, the leaked proposed rule for housing subsidy work requirements and time limits, which has not been issued yet. It will have to go for public comment, but a non-LSC funded organization is probably in a really great position to publicly comment on why some of these, the 2-year time limit for housing subsidies, as well as some of the specific work requirements, may be detrimental to some of our clients. And LSC organizations, you can certainly share that information with non-LSC organizations to be able to really provide detail to those public comments. And then finally, this is sort of a list of strategies that we can all undertake, regardless of funding. These are things that we should be doing and we should try to be doing. I want to say thanks to everybody who has bared with me for this whole hour on how complicated some of this is, because I do think first and foremost, we need to be aware of what is happening at the federal level, because it all eventually comes down to the state and local level. And so keeping track of federal actions and memos is going to be really, really important. I would also recommend maybe proactively reaching out to client groups, folks who are working with specific types of clients, disability, people who work with disability, people who work with seniors, if you have the ability, people who work with non-citizens or mixed status families, just to get a sense of what they're seeing and what their experience, because we can also provide education. We can always do that, right? We can inform those groups of what is happening at the federal level and what that means. We also want to identify practice areas that maybe we aren't necessarily, prioritizing now, but could be a area of emerging issues. We want to make sure that we're prepared for that as opposed to playing on the offensive. I've mentioned this a couple of times for our own benefit, but just also keep in mind that these executive actions will likely result in increased scrutiny. So make sure that you're really documenting the folks that you're working with, and making sure that you are really documenting your own work, right? Because there's going to come a time, I'm sure all of us will experience, where someone's going to want to 4 years. This may be less useful in Florida. I think there's some pockets where it could be. In Orange County, where I'm at, we've got some broader housing discrimination protections. But generally, if you can, and I'm talking to our South Florida folks, if you can identify state or local protections that will help individuals that are maybe under increased scrutiny or are losing opportunities at the federal level, definitely keep that information handy so that you are able to you're able to offer alternatives to clients that are in different sort of circumstances. One other tip I will definitely share with this group, this is for your grant writing, for those of us that can do any type of lobbying activity, try to reframe what it is that you're trying to accomplish for your clients. Start thinking of, how do we tell these stories in a way that it benefits all of us, to protect these rights and protect these individuals. One term you might start hearing a lot over the next 4 years is subsistence rights. So these are going to be rights that we identify as fundamental to the human condition. Things that provide basic necessities to individuals: housing, safety, income, right? And so if you can find ways to sort of shoehorn your work into those subsistence rights, you're going to have more success at grant activity, and you're probably going to have a wider range of people who are going to want to support the activities that you're doing for vulnerable populations. And then finally, let's all remember our pro bono volunteers, our law student clinics. Utilize those resources, because we can't do it all, right? We cannot do it all. We are an overwrought, overburdened system here in legal aids and nonprofits generally. So now is the time to really start mobilizing volunteer support so that we can stay ahead of some of these issues. And so then here's a conclusion. I'll just lean this up because we've talked about all of this. I know we're over time, but if there's anyone who wants to come off mute and ask a question, I'll start going through the chat and I'm happy to hear or discuss any other topics as people have time.
So I'm gonna go ahead and drop a few links into the chat. One of them
Thank you.
is if you really want to nerd out, and this is where I kind of need to plug in a big thank you for Morgan. This is a litigation tracker. There are like over 500 cases listed in there, I believe. So when this all started, like what, 11 months ago? It feels like it's been an eternity.
Mhm.
But yeah, as Morgan mentioned, it was really challenging keeping track of everything. So these are some of the tools that are available. I added more links that Morgan shared in the materials as well. With that said, I'm going to read out the CLE code out loud for everybody's benefit. I'm dropping it here again. It's 25147677N. Because I'm going to stop the recording and open it up for questions. But if you want to raise your hand, I can bring you off mute if it's a little bit easier than using the chat. But before I stop the recording, I just wanted to take the opportunity to thank you, Morgan, again for an amazing
Yeah, thank you
presentation
for
and
having
putting
me.
all this together for us. Want to thank everybody that joined us here. I see a lot of positive comments in the chat. So, with
Thank
that
you.
said, I'm going to stop the recording and open it up for questions. So, let's
Sure.
stop the recording right here.
And I do see one from Julie in the chat.